Good afternoon, and welcome to the CUA Law at the National Press Club series. I'm sorry? And welcome to the CUA Law at the National Press Club series. Today's topic is religious liberty in 2012, still the first freedom. Over the past several months, the subject of religious liberty has been very much in the headlines. In January, we saw the unanimous Supreme Court decide the Hosanna Tabor v. EEOC case, which many commentators have called the most important religious liberty decision in decades. We've, of course, had the continuing controversy over the HHS contraceptive, sterilization, and abortion drug mandate, which before today had prompted a dozen lawsuits, and as of this afternoon has now prompted 24 lawsuits, arguing that the mandate forces religious individuals and religious institutions to violate their faith. If we go back not much further, we have controversies over burnings of the Quran in Florida, the location of mosques in New York City, and statutes purporting to ban civil courts from enforcing Sharia law. At the presidential level, we have the first Mormon candidate representing a major political party, and we have continuing discussion and controversy over President Obama's former pastor. And in the past 2 weeks, we've seen the same-sex marriage debate in the headlines, bringing with it religious arguments on both sides. The president himself invoked religion as part of his argument for endorsing same-sex marriage, and the discussion of same-sex marriage inevitably brings up religious liberty issues that various states have wrestled with when they have chosen to recognize same-sex marriage. The particulars of these debates may be new in 2012, but the question of how a liberal democratic government should deal with the religious diversity of its citizens is an old one, and it's one that our nation has been dealing with for centuries, in fact, before it even was a nation. Religious liberty is the first freedom protected in the Bill of Rights. It is protected by state and federal laws. It is even a goal that federal law requires the executive branch to pursue in international foreign policy. Today, Catholic University of America and the Becket Fund for Religious Liberty have brought together a range of leading thinkers on religious liberty for a roundtable discussion about that first freedom. Why should religious liberty be protected in the first place? How well do we do as a nation at protecting religious freedom? What are the biggest challenges facing religious liberty? Are those challenges different for members of different faiths? Our goal is to have a high-level discussion about the state of religious liberty in 2012, and better yet, we are going to have that high-level discussion among a group of thoughtful and highly accomplished people of different faiths, sexes, and ages, all of whom share a commitment to religious liberty. That discussion will be moderated by Dr. Thomas Farr. Dr. Farr is a visiting associate professor of religion and international affairs at the Edmund A. Walsh School of Foreign Service at Georgetown University. He directs the Religious Freedom Project at Georgetown's Berkeley Center for Religion, Peace, and World Affairs. Dr. Farr served in the U.S. Army and the American Foreign Service and has taught at both the U.S. Military Academy and the U.S. Air Force Academy. He was the first director of the State Department's Office of International Religious Freedom, beginning in 1999 under Bill Clinton. He is the director of the Witherspoon Institute's Task Force on International Religious Freedom and a member of the Chicago World Affairs Council's Task Force on Religious Freedom and U.S. Foreign Policy. His book, World of Faith and Freedom, Why International Religious Liberty is Vital to American National Security, was recently published by Oxford University Press. Dr. Farr will be leading a discussion with the following participants. President John Garvey of Catholic University. President Garvey has been described as, quote, one of the 2 or 3 most important law and religion scholars in the United States, a constitutional and political theorist of the highest order. An expert in constitutional law, religious liberty, and the First Amendment, he has won distinguished fellowships and teaching awards. He has served as dean of the Boston College Law School and a professor at Notre Dame and the University of Kentucky. He has authored 5 scholarly books on the subject and has argued several cases at the United States Supreme Court. And as of this afternoon, Catholic University of America, which President Garvey leads, is now involved in litigation with the federal government over the HHS mandate. Sitting to John's left is Professor Doug Laycock, I'm quite certain that whoever gave the quote about John Garvey being one of the 2 or 3 most important law and religion scholars in the United States, if you ask them, well, who else is on that list, the next name out of their mouth would be Doug Laycock is on that list. Professor Laycock is one of the nation's leading authorities on the law of religious liberty. He is the Robert E. Scott Distinguished Professor of Law at the University of Virginia Law School. He was lead counsel at the Supreme Court in the Hosanna Tabor versus EEOC case. He has taught religious liberty at the University of Michigan, the University of Texas, the University of Chicago. He is a prolific author and has co-edited a collection of essays on same-sex marriage and religious liberty, and recently published Religious Liberty Volume 1, Overviews in History, and Volume 2, The Free Exercise Clause. Professor Laycock is also the 2009 winner of the National First Freedom Award from the Council on America's First Freedom. Helen Alvarez is an associate professor at George Mason University Law School. She is also an advisor to Pope Benedict XVI's Pontifical Council for the Laity and an ABC News consultant. Her scholarship considers current controversies about marriage, parenting, and new reproductive technologies. Professor Alvarez is also chair of the Witherspoon Institute's Council on Domestic Conscience Protection. And she recently made news with her womenspeakforthemselves.com website now, what began as a letter in response to the question, where are the women? After some congressional hearings, Professor Alvarez drafted a letter sent to 24 colleagues, which now has more than 30,000 signatories on the website. We also have with us Usma Udin, who is an attorney at the Becket Fund for Religious Liberty and who directs the Becket Fund's Legal Training Institute, which trains advocates, lawyers, judges, religious leaders, journalists, and students around the world in religious freedom and principles. She speaks widely on issues of gender and faith and on domestic and international religious freedom. She's also the founder and editor-in-chief of altmuslima.com, a web magazine dedicated to issues of gender and Islam. She's also an expert panelist for the Washington Post's religion blog on faith and a contributor to the Huffington Post's Religion, CNN's Belief blog, and The Guardian's Comment is Free. She was also one of the panelists who testified before Congress on the day when, according to some, there were no women. With that, let me turn it over to Dr. Farr to lead our discussion. Dr. Farr?
Thank you very much, Mark, and thanks to you and Catholic University for putting on this important discussion, and that's what it's going to be. Let me first say how honored I am to be here with this distinguished panel, almost all of whom I know very well. I know them all by reputation. They are as fine a group as you could put together of different, as Mark said, different sexes, but also different religious views, different understandings, perhaps different political views. I don't know. I haven't asked them about that. Maybe I will in the course of the evening. No matter where they come from, though, they have what I think Mark correctly said was a sense that religious freedom is a good thing. Now, I'm going to turn to each of them in a minute and ask them to give us 3 or 4 minutes of their understanding of what religious freedom means, why it's important for individuals and societies, and perhaps their sense of whether it's in pretty good shape in the United States, whether there's serious stresses. But before I do that, I'd just like to say that I've been either observing or writing about or acting upon religious freedom for the better part of 15 years now. And I've never found anyone, with the exception maybe one Saudi prince, who said they were against religious freedom. I've never really found anyone who would talk to me and say, no, I'm against this thing. Everyone seems to be for religious freedom, but there I think the agreement often ends. Because when you ask what do you mean by it and what is protected under this right, which is a different question, by the way, than what does the First Amendment protect? I mean, they may overlap, but you may have your own opinions. Then I found that there are some very, very serious disagreements around the world and within the United States. For example, in the French understanding of religious freedom, I think traditionally has been that you're free to do whatever you do on your holy day. You can go into your mosque or temple or synagogue or church and do your incantations and whatever it is that you do, but keep it there if you don't mind, because religious freedom does not mean the right to bring religion into the public square, either symbolically by what you wear, if it's garish or if it can be intimidating to others, and certainly not by making substantive religious arguments in French politics. There's an element of that in the American tradition as well. One of the most influential political philosophers of the late 20th century in the United States, a man by the name of John Rawls, made an argument that for democracy to work properly, we have to leave our comprehensive doctrines, which included religion. He argued that it included other comprehensive doctrines as well, which is one of the things we want to talk about. But he said you have to leave those things out of political argument about important constitutional matters. Why? Because religious arguments, religious ideas are... We have people over here too. Sorry for not looking at you. They're behind the podium here. We have religious arguments that are absolutist, and you can't have absolutist arguments in the public square. It'll destroy democracy. So there are just two quick examples of how people can disagree over what religious freedom means, because there are others who would argue that religious freedom does entail the right to make religious arguments in the public square, and indeed that democracy, properly understood, particularly in highly religious democracies, requires that religious people have their opportunity to make whatever arguments they want on the basis of religion or otherwise. So that's just a taste of some of the issues that we want to get into tonight. And also, of course, we want to try to apply these to some of the hot-button issues. There may be some panelists here who would like to stay away from those issues, but I won't let them do that. Now, I will say this. They're all lawyers. I'm not. I represent you, unless there's some lawyers in the audience, in which case I apologize for the slur. But these guys are all well accomplished, and I'm going to ask them to talk so that I can understand what they're talking about. Now, perhaps we could begin with John Garvey and ask, let me just repeat the question I'd like just to go down the row here and ask each of you to address. What do you mean by religious freedom? And if you want to make it the same as the First Amendment, that's fine. John won't have any trouble answering this because I happen to know he's written a book on the subject. So he may have trouble keeping it to 3 to 5 minutes, but nevertheless he'll tell us what he means by religious freedom and whether he thinks it's in pretty good shape in this country or whether it is under stress and how serious that stress might be. President Garvey.
Thanks, Tom. I don't think it'll take me 3 minutes, although I could talk for longer than that if I needed to. I would say that religious freedom is the right of an individual or a group to act on religious convictions without government interference. And I think the reason it's important for people who care about it is that for many of us who believe in religious freedom, the most important thing in life is to know, love, and serve God, and religious freedom allows people to do that without government interference. As for the state of religious liberty today, I think it's in a bad way, certainly in a worse way than I would have said 25 or 30 years ago. I would warn people against the temptation to say that this is the fault of the Democratic administration. I think that there's blame on both sides. I think that the troubles with religious freedom as a constitutional matter began in 1990 and were largely the work of justices on the Supreme Court appointed by Republican presidents who believe in government power, and said that in the Smith case that henceforward religious freedom would only protect us against discrimination, not against other kinds of interference. In the current administration, there have been a lot of activities to complain about. The actions of the EEOC and the Justice Department in Professor Laycock's case, the actions of Health and Human Services in the contraceptive mandate, or in their rules about migration and refugee services, actions by the Labor Board in saying what kinds of religious schools were entitled to protection against bargaining by their employees. There have been a lot of recent cases that have been troublesome in this sense, that the government has found itself on the side arguing against religious freedom. And when the Supreme Court decided the Smith case in 1990, it said that henceforward we should depend mostly on the elected branches of government for protecting our religious liberty. So the fact that we may not get that is a worrisome thing, and I think part of the reason why we're hearing so much about it nowadays. Does that do?
Thank you. Doug?
Well, I agree with most of that. For starters, religious liberty is for everybody. And part of the problem today is there are a lot of believers who think it's only for them, and there are a lot of non-believers who think it's only for non-believers. It is to protect everybody, and my definition would be we should minimize the government's influence on people's beliefs and actions with respect to religion. That's my global definition of religious liberty. It's not easy to do. The government is the 8 billion pound gorilla in the room, right? They spend a third of GDP. They regulate pervasively. They can fine you and take your money. They can send you to jail. So how do they minimize their impact on people's beliefs and actions with respect to religion? And I think, and these are the examples John was talking about, government should not regulate or prohibit your religious practice unless it has an extremely good reason, what lawyers call a compelling governmental interest. Because the threat to send you to jail or penalize you financially for practicing religion has a powerful discouraging effect. Leaving you alone, granting you an exemption from a law, generally doesn't encourage anybody else to join your religion or adopt that practice. There are some exceptions to that, but as a general rule, the neutral course is to exempt people's religious practices. The second great cluster of issues is financing religious institutions. It's settled in this country. Government cannot finance the religious functions of the church. But it largely can finance secular services, secular functions that are provided by religious organizations on an equal basis with secular providers of those same services. So hospitals, social services, private schools, et cetera. Everybody wants money, so if you say we'll finance religious schools and we'll finance secular schools but not religious schools, that's a pretty powerful incentive to secularize. So the way you get government out of the way is to finance everybody or finance nobody. And then the other great cluster of issues is about religious speech. Private religious speech is 100% or should be protected by the Free Speech Clause. Of course, you can make religious arguments in an American election, and we've done it from the beginning, whatever John Rawls might have thought. And you can talk about your religion in your school and in your workplace. You've got free speech rights with respect to religion. But government does not have free speech rights with respect to religion. And when government celebrates one religion's religious holidays or publishes quotations from the sacred scripture of one or a couple of religions, that, in my view, departs from neutrality. It models one way of celebrating that holiday. It takes a position on religious truth claims. I think government shouldn't be doing that. Government shouldn't be talking much about religion, and when it does, it should be scrupulously neutral. So you can see why one side likes one of my positions, and the other side likes the other one of my positions, and everyone's a bit puzzled about the third one. And that is a function of believing that religious liberty is for everybody, and the government should try to avoid interfering with anyone's belief or practice about religion, believers and non-believers alike. We're in pretty good shape compared to much of the rest of the world. We are not in good shape compared to our own ideals. And I think John's right. We're not in good shape compared to where we were 30 years ago. Better off in some ways, better off on the funding issues, certainly worse off on the government interference with religious practice issues.
Could I ask you, before we go to Helen, Doug, John Garvey mentioned the Smith decision of 1990. Right. I wonder if you could just briefly, because I think that we'll have a part in our discussion tonight, perhaps you could just describe it in layman's terms for us, what the finding was there and why it is troubling to some. And maybe whether it troubles you as much as it does John Garvey.
It does trouble me as much as it does John Garvey. So you may have heard of this as the peyote decision, although peyote actually had nothing to do with it. American Indians use peyote for religious purposes. We're already doing it when the earliest Spanish explorers came. Peyote is a Schedule I drug, so it's illegal. they use it under controlled conditions in their religious services. And so the question was, were they entitled to keep using it, or could these two litigants be fired for having attended a Native American peyote service? And it was argued in terms of whether Oregon has a compelling governmental interest in a no exceptions enforcement policy with respect to Schedule I drugs. Oregon said, we do, and the Indians said, it's not really doing any harm. There's no health risk here. It's not a big recreational drug. It's not being diverted to recreational markets. There really isn't a compelling government interest to keep us from doing this. Justice Scalia wrote the opinion, joined mostly by other conservatives on the court, Scalia, Rehnquist, Kennedy, White, and Justice Stevens, the odd man in this coalition. 5-4. So we don't have to decide whether there's a compelling interest in regulating peyote. It doesn't matter. Government can apply its neutral and generally applicable laws to religious practices, no exceptions, including to the central sacrament of a worship service. May seem odd from the perspective of most people in this room, but it was rather analogous, actually, to saying government can ban communion wine. And as long as the law applies to everybody, you don't have to ever make any exceptions for religious practice. Government can make religious exceptions if it chooses, but that's up to the state legislature. It's now 22 years later. And in an important way, we still do not know what the Smith decision means. This concept of generally applicable law was a new idea that had never been part of religion clause doctrine before, and it turns out to be ambiguous. I mean, taken literally, it would seem to mean the law has to apply to everybody. And if you have exceptions for some people with special problems with this law, then you have to have religious exceptions. There's an important opinion by Justice Alito when he was on the Court of Appeals in Philadelphia that interprets the Smith opinion that way. If there's even one exception, they had a medical exception to a rule about police officers being clean-shaven. If there's a medical exception, there has to be a religious exception. And there are other courts of appeals who say, no, generally applicable is actually a very odd way of talking about bad motive. And what the court meant was, government never has to make a religious exception unless government enacted the rule for the very purpose of getting this religion. Well, that's hardly ever going to be satisfied, obviously. So it makes an enormous difference which way generally applicable ultimately gets interpreted, and the Supreme Court has not returned to the issue in the intervening 22 years. Congress responded with legislation. 16 states have responded with legislation. Some state Supreme Courts have construed their state constitutions to be more protective. So on the books, 31 states now protect religious liberty more effectively than the Supreme Court of the United States or the U.S. Constitution does, including every large state except California. There's New York, Texas, Florida, Michigan, Ohio, Pennsylvania. But in fact, those state laws are very untested, have been relatively little enforced, and some of them quite ineffective. So Smith has had enormous impact, and taken literally, as many government lawyers would like to take it, it means they can regulate you, your church, and your individual religious practices however they want. Don't have to have a justification for intruding on your religion.
Thank you, Doug. Helen, if you can give us your answer to the earlier questions, but maybe you can defend Smith for us. Can you do that?
No.
It does have defenders, but
It
does.
Here.
I think, who is the defender of Smith? Is
Jerry
it Jerry
Bradley.
Bradley, right? Or Jerry is. I was going to reference Jerry in my remarks. I certainly agree with President Garvey's definition of religious freedom. I would add, I was going to add the phrase in talking about the scope of religious freedom within due limits. Professor Laycock referred to the government having an extremely good reason. I use the due limits language right away because in the area that I work often in in religious freedom, which is in connection with very neuralgic issues related to things like contraception, abortion, and marriage, and particularly in the context of the Affordable Care Act debate over the preventive health care mandate, the question comes, if we give religions an exemption with respect to this contraception, sterilization, and early abortifacients coverage, where will the limits be? You'll be refusing to treat people because you don't like them. First of all, that's not true on the face of the law or in our history. But second, I like to remind people that indeed religious freedom has its due limits. And the government, the law, has defined it as the state has to have a compelling state interest and to exercise it by the least restrictive means. I like to talk more philosophically sometimes. There's an author, Roger Trigg, who's written a book about this recently, and Tom gave me the opportunity to comment on it, that one looks at what constitutes human flourishing, right? And if something a religion is proposing as a matter of religious freedom is absolutely contrary to that, it's something that the law, therefore, has a compelling state interest in regulating. Obviously, there are limits to religious freedom. I would also add, with respect to religious freedom applying both to individuals and to groups, in the regulatory environment that we're in, with regulation so pervasive, and in the sophisticated environments that we're in with respect to healthcare, social services, education, religions couldn't very well carry out their mission to serve everybody in need. An absolute requirement of religions in the Roman Catholic faith, Deus Caritas Est and Caritas in Veritate, two great encyclicals of Pope Benedict, make it clear that service to those in need in the Good Samaritan way, whoever is the neighbor that comes across one's path, is required. One cannot exercise religion in that sense without doing it in a group. I would say that it's important to individuals and societies, in addition to the reasons that are already mentioned, because of matters relating to social peace, and because I think it's been very nicely documented in a book recently by Brian Grimm and Roger Fink, The Price of Freedom Denied. There are correlations and maybe causation between the presence of robust religious freedom in a society and things like equality for women, freedom of the press, and in addition, of course, to the presence of some public peace because of the absence of the clash between religions. I would be sort of like some of the older relatives in my family who talk about the world going to hell in a handbasket and things being worse now than they ever were. And I don't want to be like that if I didn't acknowledge, of course, that, there have been rough times for religious freedom all along in the United States, but I would agree with the analyses that have gone before me that we are, we're better off in terms of the government funding and neutrality issues, but we're worse off in the context of a robust grasp on the relationship between religious freedom and social good, and the good that allowing religious freedom can provide. I worry in particular right now, and again, because my other area is family law, about a particular pressure being put on religious freedom now by sort of made-up human rights, things that are more needs, things that are more wants than needs, many of them, it turns out, in connection with a particular view of human sexuality, which treats it as if it has no intrinsic link either to a bond between a long-term stable bond between a man and a woman, let alone between sex and procreation. I worry because religions, with their classic teachings about the meaning and consequences of human sexuality, are going to come under particular pressure with this new version of human rights. I worry because one can see in the way that these refusals to recognize exemptions or naming of religion as the enemy of human rights in these arenas, because of how these debates are actually conducting themselves right now, that there will be a precedent set for a refusal to look at the evidence of the good that religions have done in these arenas. And I worry because if you can make up human rights and get away with it, what other kinds of human rights will you make up in the future and then pressure religion to conform to them? I find right now that the federal government does seem particularly deaf to the historic role of religious freedom in our country and in relation to the success that we are, relatively speaking, in the world on religious freedom. I'm worried worried that we won't show leadership in this arena so as to give a good example abroad. I worry that instead religious freedom is too often being used in a political game, particularly the current, in connection with the current rhetoric about the war on women and which party is for women and which is against. Final point is, though, right now I think is a really great moment for bringing the conversation about religious freedom very much alive again. Professor Renzi mentioned I sent out a letter in conjunction with a friend of mine to 24 of our friends about religious freedom and women standing up on the side of religious freedom against the HHS mandate. And without really another lifting of a finger on my part, the letter went from 24 signatures to somewhere near 29,000 at this point, and women are getting very engaged. We're getting hundreds of emails a week with regard to their particular stake in religious freedom. So I think it's a good moment, silver lining to the current threats to religious freedom.
Okay, so we've got a few common themes here. We have a bit of a consensus on some problems developing, some stresses on the system of religious freedom. I want to widen the conversation a little bit here. I suspect Uzma will talk about some stresses as well, but perhaps in a different context. So why don't you give us your views of the answer to, the basic answer to the question, but feel free to take this in a different direction if you'd like.
Sure. I think, for the most part, I agree with everything that's been said so far. Working internationally, the distinction is often made between the forum internum and the forum externum. And this is how groups abroad define the two levels of religious freedom. The forum internum is the space in our minds and our souls where we believe in God, and we have where we house our religious beliefs. And those religious beliefs have the absolute right to be free from government interference. They cannot be limited in any way. And ultimately, this idea of it being an absolute right is grounded in the human dignity of every person. And then there's a second level, which is called the forum externum. And that's just all the outer representations and expressions of religion. And one level of this is the individual level, which is, for instance, wearing religious garb, wearing a headscarf or a turban or a cross. It's also just in terms of the way we use speech, proselytism, bringing others to our faiths. And then in terms of religious communities and what they do, communal worship, building houses of worship, training clergy, raising children in the faith. It's essential to focus on the collective aspect of religious freedom. And I know that Helen touched on this as well. And international law also focuses on that and says that religious freedom is something that we practice as individuals and in community with others. And the Free Exercise Clause also protects that right to religious association and the ability of religious groups to be able to make their own decisions and be free from government interference in how they run those organizations. There was also some talk earlier about the limitations of religious freedom, and several scholars have already focused on the domestic limitations, such as the strict scrutiny standard that says that it can be limited in the cases of the government having a compelling government interest. But even international law, the focus there is on, for instance, public health and public morals and the extent to which it interferes with the fundamental rights of others. And the important point there is always that it's all about how we interpret those, and too often many countries across the world interpret the exceptions in a way that essentially swallows the right. On behalf of the Beckett Fund, I worked on a case in Indonesia where we were seeking to repeal the Blasphemy Act. And it's basically an act that says that anything, so there's 6 recognized religions in Indonesia. Catholicism and Protestant Christianity is considered 2 different religions. And each of them have government-funded bodies that decide pretty much what is the proper interpretation of each of those religions. And the extent to which anyone deviates from that, the government steps in to punish them. And they use the Blasphemy Act as sort of the medium to do that. And we brought a case, well argued under international law and as well as Indonesian law, and also just making the point that there's so many other laws on the books that cover legitimate concerns, such as concerns about vandalism or arson or assault and battery or anything that could hurt religious individuals or religious objects. But ultimately, though, the court was really worried about is what's going to happen to societal order if we are to repeal the Blasphemy Act, if they were to repeal the Blasphemy Act. What's going to happen is that people are going to say things that are insulting to religious believers, and those believers are going to get angry, and then they're going to be violent. And so therefore, in order to protect public order, we have to limit what people can say. Of course, what completely was overlooked was the fact that a more effective way to bring about public order would be to punish the violent actor and not the nonviolent speaker. And again, I mean, if you look in even the 1970s, in the Pakistan, various courts in Pakistan, where there were cases brought on behalf of Ahmadiyya Muslims who were persecuted under provisions in their blasphemy code that said that Ahmadiyyas cannot call themselves Muslims and they cannot call their houses of worship mosques because they're not considered Muslim by Orthodox Muslims. They're considered sort of falling outside the parameters. And again, the courts in those cases said that, well, we have to allow the government to step in these cases, otherwise people will get upset and then there will be violence. And so we have to protect public order, and that's a legitimate government goal. So in terms of another part of Tom's question was also, why is religious liberty important to societies? And another aspect of that is the idea of religious liberty allows us to open up sort of this free marketplace of ideas, in this case, religious ideas. And there's this concern often with these government bodies that try to control certain interpretations of each religion. And in that process of control, what they're essentially doing is saying that we're going to protect these ideas from developing, sort of this competitive market where ideas can sort of compete against each other and be able to be strengthened and refined and reformed in that process. And so essentially there's this hindrance to that development when you don't have religious liberty. And then one of the things that Helen brought up as well was this idea of the essential role of religious liberty to national security and to the democracy in countries, because countries often, especially if they're highly religious, will fail to be stable without religious liberty. And so just jumping ahead, I mean, there's some, in terms of where the American system of religious freedom is, of course, I mean, I agree with Doug that, in comparison with the international scene, it's definitely a great place. It's something that I definitely think is worth emulating, and the other countries should seek to model. But he also made the point that, religious freedom is something that protects everyone and applies equally to everyone. And I can definitely say that as a Muslim, it's very frustrating for me, especially having such a deep knowledge and appreciation for what religious freedom is all about. That's too often, religion is used, as Helen was saying, as a sort of political football, in political football, and the same people who on the one hand will defend it for Jews and Christians will turn right around and use it against Muslims and say the Muslims don't have religious freedom. They completely forget the logic of their own arguments in other contexts. And the way they try to get out of that is by saying that Islam is actually not a religion. Never mind, that's the second largest religion in the world. And so at that, I'll leave that.
All right. Well, I want to come back to this issue of the religious freedom of American Muslims, Asma. And at the very end, if we have time, I'd like to circle back around to this issue of religion and religious freedom being a stabilizing element, as Asma put it. And also Helen made this point in referring to Grimm and Finke's book, The Price of Freedom Denied, which in fact argues, based on they're both empirical sociologists, that particularly in highly religious societies, if they don't get the religion state issue right in favor of religious freedom, full equality under the law for all citizens, all religions and all citizens, they will not be stable. They will not get what they want. And so I want to come back around to this and ask later, because now I want to come back to American religious freedom. But the United States has a foreign policy, as Mark Rienzi said in the introduction, of advancing religious freedom around the world, reflecting, I think, a notion that this thing is so important that we need to find a way, maybe the word is not export, but find a way to convince others that this is important for them as well. And I think that would be a nice thing to end up on. But I want to lay a little bit more groundwork here. And talk a little bit about how we're doing. We seem to have a number of views that we're not doing as well as we once were, Perhaps things have deteriorated at least since 1990. Some might put a little earlier. Let's go back to first things for just a moment and ask, why do we have religious freedom in the First Amendment? Is there something special about religion? I mean, remember, this is the first 16 words of the Bill of Rights, the so-called Free Exercise and Establishment Clause, which say Congress shall have no law. I'm not a lawyer, but I've learned this. It took me about 10 years, but I've learned these 16 words. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The establishment and free exercise clauses, respectively. So beginning with John, you know, is there something special about religion? Or should we, or was it special at the founding, but it's different today? And let me tell you why I asked this. We had a fascinating debate at the Religious Freedom Project at Georgetown. And on one end, we had Michael McConnell, who's one of the great jurists of free exercise in the United States, Stanford Law School, former federal judge. On the other hand, we had Noah Feldman of Harvard Law School, a really up-and-coming young scholar. McConnell basically said this, and this is obviously in layman's terms. Look, religion was special at the founding. They knew exactly, even though they weren't Orthodox Christians, they knew what they were talking about. They were talking about a kind of thirst for the transcendent. But they weren't just talking about a Christian God. They talked about Hindus, and they called them Mohammedans, but they meant Muslims. They were talking about a thirst for transcendent, a search for something we call God. That's what it meant then. That's what it means now. There are many aspects of this, and there are many people who don't do this, but religion means something. Feldman said, okay, I agree, Judge, that's what it meant then. But today it cannot mean that. We're a very different society. He didn't say this. He said, I'll spare you my discussion of originalism, so we didn't get into that. But in effect, I think Professor Feldman was saying that the Constitution ought to be interpreted today as if religion and the free exercise of religion can include the free exercise of, he used the phrase, philosophy, the search for reason, or environmentalism. I was struck by this. He said an environmentalist who's serious about environmentalism, is concerned about this, orders his or her life around this, orders his relationship with other people around a commitment to environment. This ought to be protected under the free exercise of religion as well. So my question is there something really special about religion per se? Can we define it? And somebody please agree with Noah Feldman on the panel here. Helen, if we get down to you and nobody else has, then that's your job. John.
I don't agree with Noah, but I do agree with Michael. Let me say three things. The first is about what the framers of the Constitution meant by religion. James Madison said in his famous memorial and remonstrance that what is here a right towards men is a duty towards the Creator. His reasons for wanting to protect religious freedom were that it was important to him, as it is to many of us today, to know, love, and serve God. There's my favorite book about the First Amendment is a little book called The Garden and the Wilderness by Mark DeWolf Howe. Howe says in the course of this book, The Garden and the Wilderness, about the antecedents of the First Amendment. Though it would be possible that something like the First Amendment would be drafted by people who were themselves skeptical in matters of religion, surely it is more probable that the amendment was drafted by people who themselves were believers. I think that that's true, that not typical Christian believers, but believers in the way that Tom describes. Second, let me make a point about Noah Feldman's argument. We see the same sort of expansiveness in free speech law, and it's I don't want to say a matter of doctrine, but it's something that's been frequently observed on in free speech law, that the protection the First Amendment offers to freedom of speech is in a way like taffy. The more you stretch the boundaries, the thinner the membrane that protects you. So, for example, if we limit the business of the free speech cause to protecting political speech, it will give us a robust protection against government interference of all kind. If we say that political speech is entitled to protection, but of course so is pornography and advertisements for 3-2 liquor and whatever you like, and they're all entitled to protection, then the sort of protection they're going to get is going to be diminished. So if we wanted to expand the free exercise cause to include environmentalism and philosophy, but we would find that we had a much thinner kind of protection. Third, the argument that Feldman makes is typical of arguments made in liberal political theory. Let me here make a pitch for a book. John Rawls, who thinks like Feldman on these issues, famously said that in liberal political theory, the right is prior to the good. What Rawls meant by that, the right that he was talking about, was the right to freedom. And his theory about making a liberal democracy work was that we should begin with an assumption that everybody in society is entitled to equal liberty to do whatever is important to him or her. And the reason we have to agree on freedom, the right, rather than the good, is that in a big modern liberal society, people have all kinds of desires or wishes or convictions about what's good and what's bad, and what's good for me, or what my aim in life is maybe different from you. And the most important thing is that we all be able to do what we want. That's what we can agree on. That's the social contract that we have. It's a really interesting and powerful theory. I think, though, that it does not describe the society or the Constitution that we have. The Constitution that we have doesn't protect all freedoms equally. It protects a few things. You could probably name them on one hand: speech, press, religion, some things having to do with reproduction and marriage and intimate associations. That's it. You don't have a right of any constitutional significance to hold a job as an optometrist, or to hunt or fish or drink whiskey or play baseball. These things are just not constitutionally important, although they're really important to some people. There may be people out there who say, I live and die for baseball, and it's way more important to me than sex or reproduction or religion or speech. Just give me the ball. I think that the Constitution that we do have, in the Constitution that we do have, we have adopted what I might call a kind of non-liberal argument for freedom. We really believe in freedom, but only in a few of them. Under our Constitution, the things that we give special protection to are things that are specially important things to do. So, speech is one of those because of its role in politics and because of its role in the pursuit of knowledge. Religion is one of those because it's important to know, love, and serve God. Reproduction is one of those because we all have an impulse to have kids, and same with marriage and other forms of intimate association. And the press kind of goes along with the first part of speech. That's about it. Those are the really big things. But the reason we protect them is that we think that those are really important things to do. That's my answer to Noah Feldman. We can't have a society that's going to work where everybody has an equal freedom to do the thing that's most important to him or her. We have to pick a few. They're the ones that, in general, we agree on, and we've got to protect those. It's not perfect, but it's the society we have.
Thank you. Doug, can you defend Noah?
No, but I'll come closer than anyone else will. So, why do we have religious freedom in the Constitution? You got to remember it was a Protestant country. Population was overwhelmingly Protestant. Europe and the United States had experienced 200 years of religious persecution and warfare in the wake of the Reformation. That was actually within the living memory of the American founders. The last full-scale military battle between Protestants and Catholics in England was at Culloden Moor in 1746. And so was partly to protect this profoundly important thing for every individual and church, and it was partly to preserve peace. You couldn't, precisely because religion was so important to many people, they were willing to fight and die for it. And the country, although it was overwhelmingly Protestant or very few Catholics, the Protestants were divided between the high churches that were established, Anglicans in the south, Congregationalists in the north, and the more evangelical, low church, dissenting churches, they were called, because they were not established, mostly Presbyterians, Baptists, a few Methodists, a few Quakers, somewhat differently aligned. And it was the latter groups, it was the evangelical Protestants who successfully demanded that freedom of religion, both free exercise and disestablishment, be included in state constitutions and in the federal constitution, because they thought their religious liberty was not safe so long as some other church was established. And so religion was special because of this history. It was special because it was so important to people, and it was different from most of our human activities. It was one of a few things singled out, as John says. Now, fast forward 200 years, the religious landscape looks very different. The dominant alignment of religious conflict in the founding era was high church Protestants and low church Protestants. Then for a century and a half or more, it was Protestants versus Catholics. And now it is essentially serious believers against non-believers. The statistics, I could walk you through. We probably don't have time for that. They're hard to interpret. Only 2 or 4% of the population self-identifies as atheist or agnostic. But it's in the neighborhood of 30% that have no significant interest in religion. 30% say 30% of married Americans didn't have a religious wedding, and 30% of Americans don't expect to have a religious funeral. And then you got the people who only show up to be married and buried on top of that 30%. So there's much to John's point about taffy pull, but there is a different point. In 1789, the whole country had a religion in the conventional sense, and guaranteeing religious liberty in an open and obvious way protected everybody. It was a sort of non-aggression pact, mutual non-aggression. You leave my religion alone and I'll leave your religion alone. 30% of the population non-believers, religious liberty that only protects believers starts to look like a special interest demand, right? And it becomes more and more difficult to defend. And one of the functions of religious freedom is precisely to mediate these religious conflicts. Mediated Protestant conflict, mediated Protestant-Catholic conflict. It took a while for Catholics to get their religious liberty taken seriously. And today, I think it has to mediate the religious secular conflict. That doesn't mean that everybody who feels strongly about his passion has a religion. I think it does mean that that non-believers can't be singled out because of their non-belief, that when they do things that are analogous to religious things, to religious functions, they ought to be protected. And it doesn't come up very often, but it does come up. Some of the applications are obvious. Non-believers' speech about religion is protected to the same extent as believer speech. And, believers can say Jesus Christ is the most important thing in the universe, and non-believers can say that's a crock, you just made it all up. And they're both protected by the free speech clause. There are cases, there are decisions.
Doug, if I could just hone down on that for a second. Wouldn't the person talking about Jesus Christ be protected under the free exercise clause of the First Amendment? And are you arguing that free exercise of religion would include this other person because they felt strongly about it?
That's sort of an academic question with respect to speech. Nothing really turns on it because you're going to get the same protection for religious speech whether you do it under the speech clause or whether you do it under the free exercise clause, because the court is very concerned about preferring some viewpoints over others. But the hard question is, and it doesn't arise very often, but it does arise, the deeply held moral commitments of non-believers, do they get protected conscience objection status in the same way that believers do? Well, believers don't get it anymore anyway, and under the Constitution, according to Justice Scalia. And part of the reason for Scalia was he didn't want to decide what interests were compelling and what interests were not. But much of the reason that position has gotten support, especially in the academy, is the view that exemptions for believers are discriminatory. I think in principle, non-believers with deeply held conscience objections ought to be protected as well. That's how close I can come to Noah Feldman. It doesn't mean everything you feel strongly about. It does mean claims of conscience. And it doesn't arise very often because the moral commitments of non-believers tend to be more in sync with the moral commitments of the dominant political forces in the country, in part because they're not taking their morality in any sense from books that are 1,500 or 2,000 years old, in part because there are not that many things they feel that deeply about. They don't have ritual obligations. They don't have liturgical obligations. The one place where this has come up repeatedly was the military draft, and the military draft has been repealed. But I do think the deeply held moral commitments of non-believers ought to be protected, and I would do that under the Free Exercise Clause. That ain't Noah Feldman, but that's as close as you're going to get from this panel, I suspect.
I suspect you're right. Helen.
I want to take up Doug's challenge not to be on Noah's side. I'm not, but I can come close to understanding what Noah's thinking and sympathize and want to see it taken care of, possibly legislatively, but not with rhetoric that talks about people of faith being a special interest group. I tend to agree with John Garvey's statement there. We are in a democracy, liberal democracy that works with a very few things highlighted for special protection. And if we want to extend this protection beyond what its explicit language is now from religion to deeply held, even comprehensive value systems that are not religious, then I think that to do that legislatively is good. To do it on the basis of language in the Constitution, I don't think is necessary. I think I understand from Doug's data. I look at all that Pew Forum data, if that's what sort of something that you're looking at regularly also, that, you don't want a perception even politically to arise that one is favoring the deeply held commitments of religious people over others, to create social rifts. We don't want this. It doesn't happen all that often. People who hold comprehensive worldviews based on things like environmentalism or even some secular version of the Golden Rule don't have the problem of having an establishment clause suggest that there's certain things they can't do with it, whereas religious people do have that constraint. And so I don't think they're going to run up against the same kind of series of problems that religious people have had in trying to be active and alive and contributing to the public square. But I can understand that from the data and Noah's position that, wow, if you really do have this comprehensive worldview, and if we hold as one of the rationales for valuing free exercise that it encourages sort of citizen happiness and sense of freedom and social peace because people feel that they're able to pursue the thing that is most important in their life, the thing to which they have to answer, then you certainly want to go some distance toward answering that for people. I think as a political matter, as a matter of public peace and freedom in a liberal democracy. I just wouldn't do it as a constitutional matter. I think I would leave it at a legislative level.
Thank you. Esma, do you want to jump in here?
Well, I don't have much more to add. I just think additional point is that throughout our history, we have recognized a special sort of nature of religion, also as just sort of helping to place our source of rights as somewhere outside or beyond the government, beyond the state. And I think that's something that's been an important point that we've always sought to recognize and what makes religion different and special as compared to other belief systems.
Indeed, religious freedom.
If I could add just
Sure.
one thought, Tom. The other thing that's changed is our willingness to kill and die for our religions. Still goes on in the rest of the world, not too many Americans. That's a good thing. But in the view of some, it means we don't really need this religious liberty stuff anymore. It's not essential to keep the public peace. And governments believe those make the rules, and religions will, for the most part, fold. And I think we're about to test that with the contraception and abortion requirements.
Let me press you a bit, Doug, on the proposition, if I understood you correctly, that religious speech is protected under free expression, and that there's really no constriction on the public expression of religious views. Let me raise the case of Prop 8 in California, and I'll ask you about it, and others can jump in if they like. The question, of course, was the definition of marriage, and there was a referendum, which, of course, is citizens voting on a proposition, which, as I understand it, would have defined marriage in the California Constitution as between one man and one woman, implicitly rejecting same-sex marriage. And it passed in 2007, 2008, but in 2010, a federal judge declared it unconstitutional on a number of grounds, but one of them, and I don't usually read these things, but I did try to read this one, and again, it took me several months to get through it, but here's what I thought it said. One of the reasons this referendum is unconstitutional is that the arguments against it, against gay marriage, against same-sex unions, were, quote, religious, based on religious and moral values, unquote. Now, it wasn't clear to me whether he was drawing on, I don't think he did explicitly, the notion that this was religious animus. I don't know that word is used in the decision. But I read this as a federal judge saying that if you make religious arguments against gay marriage and you win, then that cannot stand. Am I reading that wrong?
Well, if you're reading it right, then he was wrong. Life is short. I have plenty of religion clause cases to worry about. I actually did not read the district court opinion in the Prop 8 case. So there are two things.
You heard it here. I read a case that Doug Laycock had not read.
So there are two things he could have been saying. One is religious arguments are inadmissible under the Establishment Clause, and anything that is passed for a religious purpose is, for that reason, unconstitutional. And there are a lot of academics who believe that. An incredible number of books have been written about that over the years. It has absolutely no support in any Supreme Court case. The court has repeatedly said otherwise. It has absolutely no support in the experience of American history, in which religious arguments have been prominent every time there was moral disagreement about a political issue. And it makes no sense in terms of any understanding of the First Amendment, because it says some citizens don't have free speech rights that other citizens have. Now, there's a second thing he could have been saying, which is more plausible, and that is there is prima facie or presumptively a constitutional right to choose your own marriage partner, and therefore a right to same-sex marriage. And the question is, does the government have a sufficiently important interest to override that right? Now, obviously, the existence of such a right, even presumptively, is highly controversial, and it doesn't come out of the religion clauses if it comes. But he plainly believed there was such a right. What kind of government interest is sufficiently important to justify interfering with or prohibiting the exercise of an intimate personal right like this? some other groups' religious or non-utilitarian moral views just can't be enough to violate someone else's liberty in this way. You've got to show some kind of concrete or tangible harm. That's what we mean by compelling interest. To the extent he was saying that, I actually think that's quite plausible. It's also obviously quite controversial. But that's an argument about what does it take to override another constitutional right that's been identified somewhere else in the Constitution outside the religion clauses. It's not this more general academic theory about religious purposes making legislation unconstitutional as a general matter under the establishment.
So you have to buy the premise. I mean, the premise.
You have to buy the premise that there's a right somewhere else to gay marriage in the first place. And the example I always give my students about this argument is 5 years or so ago, there was a referendum in Alabama to change the tax code. And the explicit argument in support of this referendum is the Alabama tax code is so regressive, it so grinds the faces of the poor, it is unchristian. And this is a very religious state, and we should pay more attention to the Sermon on the Mount, and we should tax the rich more and the poor less. Alabama voters were fine with grinding the faces of the poor. The referendum failed. But, had it passed, I think only a handful of Looney Tunes academics would really think it was unconstitutional because of the religious arguments that were being made in favor of it. And the nice thing about that example is that it flips the usual political polarities. This argument is coming up with respect to interfering with people's sex lives. And folks who are worried about abortion rights and worried about same-sex marriage rights think, what a cool move to exclude all these religious people from the debate by saying you can't make a religious argument. And I like the Alabama tax referendum as a counterexample to that.
Great. Well, I'm glad we don't have any academic Looney Tunes on the courts. That's very reassuring. Helen or John, did you want to address Prop 8 or USMA?
I'll be happy to say something about it. It'll be very much like what Doug said. I think Doug's second interpretation, is a really charitable one. Let me make a different kind of distinction. Sometimes, like in interpretation 1 of the district court's opinion, or like some of the language in Lawrence against Texas, we see the court saying that it's improper or that there's no legitimate state interest in taking account of morality and passing legislation, that preventing people from doing something that they want for moral reasons is simply beyond the pale. This is commonly heard in the gay marriage cases. I think that's demonstrably false. To give just a few examples, we have laws against obscenity, which the Supreme Court enforces for moral reasons, and polygamy laws and incest laws, but also things that might not be so obvious. For me, the best, maybe the only really convincing argument in favor of Brown against the Board of Education is that it's just wrong to separate people in their education on the basis of race. This is Professor Black's argument about why Brown against the Board of Education is right. I think that our deep societal commitment to racial non-discrimination is, in the last analysis, a moral objection to that sort of treatment. You might say the same thing in just a few years ago in a case called Atkins against Virginia. The Supreme Court said that it was unconstitutional to impose capital punishment on mentally retarded people. And in making its decision, it relied on a brief filed by the United States Conference of Catholic Bishops saying that this was immoral behavior, and that's why we shouldn't do it. So I think the people who make these arguments that you can't impose your morality through the law are just the people make those arguments in both directions, playing false to their own argument. That's one sort of thing. Another sort of argument is that you sometimes hear, like John Rawls's argument, is that in a liberal democracy it's wrong and maybe unconstitutional to make specifically religious arguments that appeal to principles, what the Bible says, what the Quran says, as a reason for adopting one form or another of public policy, like the example that Doug gave. I think there, too, the free speech cause and the free exercise cause unite in protecting people's right to make any argument they want for the passage of laws in the public space, and that's how we run our government. And have from the very beginning. And if one of those efforts succeeds, like the argument for a more progressive income tax, or the argument against the argument in favor of prohibition, or the argument against funding abortion, there's nothing wrong with the outcome. The fact that religious people support the law for religious reasons is not an argument against its usefulness. The only case where specifically religious arguments, I would say that specifically religious arguments are never forbidden, but if the government were to pass a law that had only a specifically religious purpose, everybody must receive communion once a year in the Church of England or the Episcopal Church in the United States, a law like that would be unconstitutional, not because of the arguments that were made in favor of it, but because it does no work other than religious work. That's something that's forbidden, but we just don't do that in America.
Helen or Uzma?
You know, I would like to go even a little further than President Garvey on the question of religious contributions in the public square, and I think about this a lot, and I'm still thinking of it, so bear with me. But I don't know how many of you have read the work of Francis Frank Beckwith. He's at Baylor University. He has an article called "Why Does Religion Sit in the Back of the Bus?" And he talks about the different testimony that was brought in connection with federal stem cell, funding, and he makes the case that I like, and I try and use it in scholarship in family law, that sometimes argument that is religious, and this is tricky, right? Because some religious traditions believe in natural law, and so they use a lot of references to everything from genetics to studies on adult versus embryonic stem cells and what that might indicate. But I do believe that there are things that religions say, and where do they come from? They come from their experience serving the poor or immigrants, from their experience, protesting at nuclear weapons facilities or abortion clinics. They come from their experience not just with issues but with whole movements, civil rights movements, abolition movements. And they say things, and I'll use some examples like, you can't find yourself until you lose yourself in service to the other, or she who is first shall be last, and vice versa. Or, the way that the common good is carried out is X, is attention to the most vulnerable. Now, these are things that people might discover from experience in their own lives, right? And they might even be things that some great sociologist or demographer can test. And you get that sometimes, right? They do studies that have these interests in the happiest people or the people who, give the most to charity or whatever. But I think that I would like to propose that religions, even those that don't explicitly have a natural law foundation or public presence, might have something to say that at least ought to be heard at the hearing table. And we can decide in a democratic republic to vote yay or nay on that. I agree with President Garvey, the question of laws that only do religious work, obviously that's out. But on other laws, I believe that a combination of experience working with human beings, a certain kind of anthropology, experience with issues and movements, that Frank Beckwith is right, and that religion shouldn't sit in the back of the bus, but actually should have a place at the hearing table.
So,
this is a very old argument. The supporters of Thomas Jefferson said the Federalist preachers in New England should butt out of the election of 1800. And Stephen Douglas of the Lincoln-Douglas debates said the abolitionist preachers were violating the separation of church and state by talking about slavery. They should preach Jesus Christ and Him crucified and stay out of the political issues of the day.
Stephen Douglas did not win that debate.
He did not. And by a few years later, it's either the third or fourth verse of the Battle Hymn of the Republic, of course, says, "As He died to make men holy, let us die to make men free."
Indeed.
And the guy who won the election said this the second time around: "The Almighty has His own purposes. Woe unto the world because of offenses, for it must needs be that offenses come, but woe to that man from whom the offense cometh." This is Lincoln's second inaugural address.
Asma.
Just to add a minor point, I agree that there shouldn't be any limits on the extent to which religious arguments can be used in the public space. I think a totally separate issue is whether religious arguments are the best arguments to use. And I think religious arguments, like all other ideas, have to compete in the marketplace of ideas and have to be shown to be persuasive. And so I think that there's a need for religious believers to really engage those who don't believe and be able to convince them of, just like any other proponent of ideas, that their ideas are good and right.
Right. So there seems to be a consensus that it is not unconstitutional to make these arguments. Sometimes it may be politically stupid or they may be wrong, but there's no constitutional prohibition on making these arguments, even if you carry the day and win on a public policy issue, unless they do, as John Garvey puts it, no other work than religious work. I want to go back to Asma, though, and just turn for just a moment to the American Muslim experience with respect to religious freedom, and maybe just picking up on what we were just talking about. You don't see a lot of or at least I'm not aware, and I try to watch a lot of American, specifically Muslim Quran-based arguments for laws and public policies, with the exception of the question of Sharia law. And this has mainly come up when states have tried to bar it preemptively. So it might be helpful for us, and it would be helpful to me, if you just talk a little bit about this. I mean, is there a way to think about Sharia law that is not scary, that can fit into the American system of religious liberty?
Well, the first thing I would say, it's not a question of can it fit. I mean, it has fit. And so I think, for lack of a better term, I'll call them Islamophobes. Those who go about sort of promoting an exaggerated fear of Muslims and this idea that we're all out to take over the country, even though we constitute probably, I think, 1% of the population of the U.S. We're trying to take over the country and impose Sharia on the American legal system. Never mind that Muslims have been in this country since the time of slavery, and that hasn't happened yet. And then never mind also the fact that we have engaged in Sharia arbitration. Some Muslims do, to be able to sort of arbitrate their personal issues, such as divorce, and other family law issues. And again, we don't see any sort of creeping. We haven't seen the Sharia take over. We know about Oklahoma was one of the states that passed the anti-Sharia initiative, a ballot initiative that specifically said that Sharia specifically should not be allowed or considered or referred to by American courts, and yet there had been not a single instance in Oklahoma where that had ever been the case. And so it was a little bit puzzling that they were putting out this initiative to get rid of a problem that didn't exist. And so, again, going back to the question of, Sharia, just like a number of other religious laws, have been used in arbitration, private arbitration, and there are built-in protections in the American legal framework that make sure that they don't sort of take over the system or in any way hinder its effective functioning. All decisions by an arbitration court have to be, in order to be enforced, they have to go to a civil court, and a civil court has to check them for substantive and procedural fairness. And so there have been a number of cases, especially the ones that are often used to kind of spread this fear. If you actually analyze those same exact cases, you'll see that in all such cases, the courts were doing exactly what they were supposed to do. The one that's been used most often is the case in New Jersey, where a husband argued against when he was accused of marital rape, that this is allowed in sort of the Muslim framework, and that it was allowed by Sharia. And while the lower court made the mistake of accepting it as a cultural defense, it was immediately overturned by the appellate court, and saying that that was completely an illegitimate use of a religious justification. And if you look at a number of other cases, such as there's an Amin v. Bakati case where an Egyptian court had ordered that the Muslim father automatically be receive custody of their child, and when that order was attempted to be enforced in the U.S., the Louisiana court said, well, the standard here in the U.S. is that we always look at the best interest of the child. And so we're going to use that policy, our public policy that we have in this country, in that state particularly, to override this sort of Sharia-based order that was handed out by an Egyptian court. And so I guess just the short answer is the fact that we don't have to worry about the Sharia threat, and the fact that the system has built-in protections and has used it the way it's supposed to.
I suspect a lot of Americans associate Sharia not with the kind of things you're talking about, with what they read about it in Pakistan or Saudi Arabia and so forth. And this may be some of the source of some of the fear and confusion about it.
The Oklahoma bill was struck down in part because it singled out Sharia for special mention. If they try to disguise what they're doing and say no religious law, well, there are Catholic canon law courts for priests and religious. There's a substantial amount of Christian arbitration in the evangelical community. There are large systems of rabbinical courts, especially in the Orthodox Jewish community. Legislators have no idea all this stuff is going on, but they're going to be trampling on religions that they actually respect somewhat or care about in their effort to pick on Muslims.
I read in the paper yesterday that I think his name is William Peter Blatty, the author of the book The Exorcist. People familiar with Blatty? He's a pretty old guy now. He's a graduate of Georgetown. He's suing Georgetown in a canon law court, suing to have its status as a Catholic university reversed. So we'll see how that's a sort of a Catholic version of the same problem, or if you like, the same opportunity.
It hasn't happened to Catholic universities.
Beg pardon? No. And I dare say it probably won't. Okay, we have a couple of minutes left here, and I'd like to turn to our audience. We've covered a lot of ground here, but we'd love to involve you in the conversation. So if anyone has a question, we have a couple up here. If you, this gentleman first, and then you, if you would identify yourself and ask your question.
Hi, Jeremy Greiner. I'm Professor Alvarez's biggest fan after watching your presentation at Steubenville. So Professor Laycock mentioned about this second issue that perhaps the judge for Proposition 8 talked about, this presumptive constitutional right to choose your marriage partner, and that would introduce the idea of what kind of interest does the government have in that. So I would like to hear your thoughts on what interest the government has in picking your marriage partner.
Okay, I'll be brief since it doesn't go to the heart of the religious freedom stuff we're doing. But to me, essentially, it seems very obvious to say that the government has a particular interest in linking a man to a woman to their children that is not shared in a situation where that is not occurring. And even if this weren't obvious based on histories of marriage from millennia, Edward Westermarck's The History of Human Marriage, or other things, it should be obvious from emerging literature that the last thing we need socioeconomically as a divide between, current citizens and new immigrants, or between the races or socioeconomic classes, is to say that it is not in the public interest to link a man to a woman to a child. We see from all the recent studies, Kay Heimowitz, Brad Wilcox, Charles Murray, that we are experiencing a divide in families between socioeconomic groups that is then reflected in the stability and economic security of the larger community that they live in, that is really surrounding marriage and marital parenting. So the bottom line to me is that you don't have to talk about religion whatsoever in order to assert that the state has not just a rational relationship in preserving marriage, but really a compelling state interest.
This gentleman here.
My name is Paul Zimmerman. I'm a retired
Microphone there,
Here it comes.
Professor.
My name is Paul Zimmerman. I'm a retired attorney, and I've always been very interested in the issue of separation of church and state. Most of what I've heard from the panel, and it's been very interesting, has involved the possible threat and actions of government in relation to freedom of religion and freedom of speech within that context. I'd like to know what the panel believes are the issues involved with freedom of religion, religious expression within religious institutions. And since I'm staring at 10 panels that say Catholic University of America, I'll be more specific about it if I can. Why and what are the legal issues involved in the church's decision to investigate this order of nuns and their freedom of expression, freedom of religious expression, and what was the interest in the Catholic Church and the bishops in trying to prevent Secretary Sebelius from her free speech at a Catholic university?
I love the question. I hope it was directed to me. So let me say 3 or 4 things in reply. First, about the free exercise of religion. The 18 words of the First Amendment are, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Religious freedom, like the other freedoms we have in the Constitution, are rights held against the government and not against other people. In fact, if you look at all of the rights that we have in the Constitution, except for the 13th Amendment, they're all protections against government action and not against individual action. So there is no such thing as an interesting constitutional or even statutory right to religious freedom against a religion that you might belong to. Second,
But there is a right to leave that religion.
Second, of course there is. Second, there's a tendency, and it's a peculiarly American thing, although we see it in the West more commonly, to try to understand religion as an individual experience. And there are examples of this in popular and important Western religions. One of the big differences between Protestants and Catholics arising out of the Reformation was the notion held by Protestants of the priesthood of all believers, that your interpretation of Scripture and your relationship with God was not something that had to be mediated by a church. So I don't deny that religion is or can be an individual experience. What I want to affirm is that in many religions, our understanding of our relationship to God is a group experience in an indestructible way. In Judaism, you need a minyan to sit Shiva. You need 10 people. One person can't sit Shiva. In the Catholic Church, you need a congregation to celebrate Mass. You can't, priests can't, without dispensation, say Masses on their own. In many Protestant understandings of faith, to take Rudolf Bultmann, salvation itself is something that's given to the church, not to the individual. And the individual is saved insofar as he or she belongs to the church and not on his or her own. So religion is, for many people, certainly for Catholics and for many others, Protestants, Jews, Shiite Muslims, a kind of group experience, which, and so, third, in those views of religion, where the religion itself is a group experience, the institution itself has a kind of integral religious importance. It has rights under the First Amendment. Churches, not just their members, have rights against the government. And when churches hold these rights, the government has no business messing with the relationship between the church and its members. Doug won a really important case, Hosanna Tabor, this year, that was in essence a fight about that principle, whether the government could say what should be the relationship between a Lutheran church and its teachers of religion. And in the lawsuit that we filed today against Health and Human Services, it's a claim on the part of the institution, the Catholic University of America, that it should not be forced to subsidize activities that it, as an institution, views as immoral actions. It may be the case, it is the case, that we have employees and students who dissent from the Church's teaching about contraception. Some may even dissent from the Church's teaching about abortion. Nevertheless, the right that we're asserting is a right that we hold as an institution to observe the principles of our faith. So the same is true about relationships between the Church and people in vows or so on. I think I don't say that the understanding of religion as an individual thing is itself mistaken, only that the attempt to universalize that concept of religion, to assert that the government or the Washington Post or some other group has an interest in mediating the relationship between the Catholic Church and its members is an effort to apply an individualized notion of religion that Catholics don't really hold.
Yeah, I agree with all that, but I would emphasize the point that went quickly in passing. The protection in our system is the right to exit. Right? That's what people didn't have during the Reformation, and it's what people don't have in some Muslim countries today. The Church has no power over its members except the power that is conferred by their religious commitment and their unwillingness to leave. So you can start your own church, you can declare yourself a preacher, you can try to find a following, but if you want to be a Catholic nun or if you want to be a Lutheran religion teacher, you got to do it under Catholic rules or Lutheran rules within an institution. You can leave, but if you stay in subject to whatever authority structures and doctrines that church has created.
That reminds me that I didn't address your question about Kathleen Sebelius and Georgetown. And let me make 2 points about that. The first is the point that Doug just made. I noticed that the Post has been interested in the dispute between the Archbishop of Washington and Georgetown University. And the Archbishop of Washington has no power over Georgetown University under civil law or probably, well, I don't know, I wouldn't get into his canon law rights, but he has no power in our legal system over Georgetown University other than to say, okay, you're not allowed to call yourself Catholic anymore. That's the only authority he has. He can't do anything else, can't fine them punishment. That's point one. Point two is, I'm disappointed in the news coverage of this debate, which arises every year when Catholic universities in particular have disputes over who can be their commencement speaker. Take the case of Secretary Sebelius at Georgetown University. The dispute there is not about the free speech rights of Secretary Sebelius or even her rights to speak at Georgetown University and say whatever she wants. The American Catholic bishops have had nothing to say on that subject. She's free. In fact, Georgetown would be encouraged by norms of academic freedom and its own status as a university to bring people like Secretary Sebelius, who is an important and influential member of the government, to campus to explain what's up in her department with all of these recent interferences with religious freedom. What the American Catholic bishops have said, and what the Archbishop of Washington has repeated, is, look, that's fine. We just shouldn't give honors, platforms, or awards to people who hold views at variance with the views of the Catholic Church. If I can give an analogy, what they've said is that we shouldn't endorse those people. And consider this analogy every year. Along with these fights over who can talk at Catholic campuses, we'll have a fight over who can talk at public universities. Montana State University will invite the local minister or preacher or priest or rabbi to come and give an invocation at the commencement exercises for the Montana State University Flying Ducks. And every year, the American Civil Liberties Union will file a lawsuit against Montana State University for allowing the preacher to come and pray at the commencement. I happen to agree with both the Archbishop of Washington and the ACLU. I think that the point of First Amendment law, as the Supreme Court explains it about commencement prayers, is that it's no part of the business of government to endorse a particular form of prayer or a particular form of piety. that the government is, and the public universities run by the government are not and shouldn't be in the business of leading people to pray, and we shouldn't endorse that activity as opposed to another one. So in both cases, both the bishops and the Supreme Court are saying that we shouldn't endorse views of one kind or another. Nobody ever says that the ACLU or Montana State, or that the ACLU is denying academic freedom or rights of free speech in claiming that the preacher shouldn't come. And people shouldn't say that about the Archbishop of Washington either.
Let me stop the discussion there. I hate to stop it. It's obviously a discussion that has been going on in this country for centuries and will be going for centuries, but we were supposed to stop at 6:30. So thank you very much to all of our panelists for a fantastic discussion. Thank you all for coming. Have a good night.